Hello friends! In this video, we provide practical information to our fellow professionals on how to be a successful expert witness, and we explain how to be confident before any court or tribunal. This video is based on advocate's 16 years experience and 8 years as an advocate in the arena of child protection. This video will also help you overcome the fear of giving evidence as a professional witness. When we say professional witness, we mean the social worker as an expert. Social workers as professional witnesses are qualified by their knowledge, skills and training and are able to prepare evidence and give opinions on a particular issue to a court. Their role as social worker is to assist the court on issues within their expertise. The social worker's primary duty is to the court, and this is over and above the duty to his or her employers. If the social worker's view is going to be different to what was a previously held view, then such a social worker must inform his or her employer, and the court should be notified of this. If the witness proceeds to give oral evidence, then the court is put on notice that the social worker's view is in conflict with a fellow professional, and the judge will take this into an account. Theoretically, a social worker has a duty to act independently and not to be influenced by his or her employers. Social workers are experts in their field of practice. As a social worker, you have been trained and have become skilled at using theories, hypotheses in your practice, and assessments. When you give oral evidence, the judge will want to know how you became involved with the family. What practice orientation have you or your team adopted? How have you approached the case? Was this a crisis intervention approach? What perspective did you or your team bring to bear on this case? What is the setting of the case? What skills have you deployed to the case? If you need to make mention of other experts, such as Maslow's hierarchy of needs, to present your evidence, then do so calmly and make sure it is relevant to the point that you are trying to communicate. Don't be afraid to use big works such psychoanalysis and attachment theory, because although these topics border on psychology, they are well within your remit. Don't just say the local authority has supported the family. Tell the judge precisely how the family was supported by giving specifics such as, I visited the family 3 times a week and a family support worker 3 hours every day of the week except Sunday. Tell the judge the task you did with the family or the task the support worker did with the family. Always remember to let the judge know the positives about the family, no matter how bad the situation. For example, the couple loved their child, and tell the judge how they've demonstrated this. We are now going to spend about 5 minutes discussing a few legal principles. Let us kick off with the legal principle called balance of probability. It is very important that you have a good understanding of this legal principle. You should try to keep it at the back of your mind when giving oral evidence, or indeed when you are preparing your written evidence. Simply put, this is burden of proof in civil trials. The common distinction is made with the burden of proof in a criminal trial, which is beyond a reasonable doubt. In a civil trial, one party's case need only be more probable than the other. Any child protection proceedings investigated by a local authority will invariably be a civil case or trial. In the case of a child, Rev 1, reported in 2015, EWFC, from page 11, the judge said it was for the local authority to prove, on a balance of probabilities, the facts upon which it seeks to rely. It is for the local authority, since it is seeking to have A adopted, to establish that nothing else will do. This principle was echoed in Re B, A child, care proceedings, threshold criteria, reported in 2013 UKSC from page 33, and was also mentioned in Re BS, adoption application of section 47(5), reported in 2013 EWCA Civ from page 1146. This same principle was also emphasized in Re R. A child, reported in 2014 EWCA Civ from page 1625. In the case of A child, Re Rev 1, reported in 2015 EWFC from page 11, the judge said one of the fundamental principles in preparing the case is proving the facts in issue to the standard of balance of probabilities, because oftentimes it falls far short. In that case, the judge had this to say on the point. The first fundamentally important point relates to the matter of fact-finding and proof. I emphasize, as I have already said, that it is for the local authority to prove, on a balance of probabilities, the facts upon which it seeks to rely. I draw attention to what, in Re A child, number 2, reported in 2011, EWCA Civ from page 12, particularly paragraph 26, I described as the elementary proposition that findings of facts must be based on evidence, including inferences that can properly be drawn from the evidence, and not on suspicion or speculation. This carries with it two important practical and procedural consequences. The first is that the local authority, if its case is challenged on some factual point, must adduce proper evidence to establish what it seeks to prove. Much material to be found in local authority case records and social work chronologies is hearsay, often second or third-hand hearsay. Hearsay evidence is, of course, admissible in family proceedings, but, as the present case so vividly demonstrates, a local authority which is unwilling or unable to produce the witness who can speak of such matters first-hand may find itself in great, or indeed insuperable difficulties if a parent not merely puts the matter in issue but goes into the witness box to deny it. As I remarked in my second View from the President's Chambers of 2013 Fam Law from page 680, of course the court can act on the basis of evidence that is hearsay, but direct evidence from those who can speak of what they have themselves seen or heard is more compelling and less open to cross-examination. Too often, far too much time is taken up by cross-examinations directed to little more than demonstrating that no one giving evidence in the court is able to speak of their own knowledge, and that all are dependent on the assumed accuracy of what is recorded, sometimes at third or fourth hand in the local authority files. It is a common feature of care cases that a local authority asserts that a parent does not admit, recognize, or acknowledge something, or does not recognize or acknowledge the local authority's concern about something. If the thing is put in issue, the local authority must prove the thing and establish that it has significance attributed to it by the local authority. The judge said the failure to understand these principles and to analyze the case accordingly can lead, as here, to the unwelcome realization that a seemingly impressive case is, in truth, a tottering edifice built on inadequate foundations. The judge was also unhappy at the social worker's understanding of the meaning of significant harm. We will not discuss this point in the video because you have not done a video called What is Significant Harm, which deals with this issue, and I recommend that you view the video. We are now going to discuss the practicality of building the evidence for the case. Let's have a quick look at how the principles we've just discussed affect the pre-proceeding stage. This is the stage when the social worker is gathering information to assess the needs of the children and family. This will include both good and not so good information. Both sets of information is called evidence. However, how you gather or present it will determine whether the court is able to rely on it or whether it will disregard the so-called evidence. The following 5 points are a guide on how to gather information. Number 1. Information must be recorded accurately in the best format available and as soon as possible. Number 2. When writing down the information, please include the name of the author, date and time, and where possible, who said what to whom. Try to be specific where possible. The child, Tom, told the social worker that Mr. D was domestically violent is far more useful than the children expressed that there was domestic violence. Number 3. The social worker must present her written evidence or oral testimony in a balanced way. In the case of Re B minors, care proceedings reported in 1994, 1 FCR at page 471, the judge said, "I cannot emphasize too much that applicants, such as a local authority responsible for children in their care, and in particular responsible for seeking so far as possible consistent with the children's welfare to keep the children with their parent, should not act in a 100% adversarial way. If they are presenting a case, they must present it in a balanced way and not fail to refer, it seems deliberate, to factors which point in the direction opposite to that which is desired by the local authority. I propose to say no more about that." Even if a mother is legally represented and the social worker cannot find anything good to say of the mother, it is likely that this approach would negatively affect the reliability of what the social worker has said or presented in written evidence. Number 4. The picture of the chaotic room will say what 1,000 words cannot. Therefore, the best evidence of the state of the room could be the picture. If the police or other organisation provide you with some information, then, if possible, ask the organisation to put the information in writing so that the information is not only recorded, but you have the original evidence. It will also be difficult for anyone to say it was not the case. There are different ways of classifying a piece of evidence, but, for the purpose of child protection, judges are likely to be more flexible on the rules of evidence, so I am not going to provide you with the complexity of rules of evidence. Number 5. If a statement has been prepared, please make sure the statement is signed and dated. Now let's go back to discussion we were having about how to give oral testimony. Firstly, you should come to court in formal dress code. Avoid scruffy clothes because the personal appearance or presentation of a social worker will affect the perception of whether you are a competent professional as you claim. Avoid yawning or slouching as these attitudes portray an uncaring and nonchalant person. It is not every disagreement between the parties that will result in a social worker giving full oral evidence. The judge will often decide whether limited oral evidence will suffice, and this is a discretion the judge has. In the case of B minors contact, reported in 1994 to FLR, the judge ruled that in the case such as care order, revocation of care orders will usually be decided on full oral evidence, but there are many times when full oral evidence may not be necessary. Do I swear or do I affirm? In law, an affirmation. Do I swear or do I affirm? In law, an affirmation is a solemn declaration allowed to those who conscientiously object to taking an oath. An affirmation has exactly the same legal effect as an oath, but is sometimes taken to avoid the religious implications of an oath. It is thus legally binding, but not considered a religious oath. Some religious minorities hold beliefs that allow them to make legal binding promises, but forbid them to swear an oath before God. Additionally, many decline to make a religious oath because they feel that to do so would be valueless or even inappropriate, especially in secular courts. Usually, the court will ask whether you wish to take an oath or make an affirmation. So who gives evidence first in children proceedings? Generally speaking, the order of adducing evidence before the court is in the following order. The applicant, any party with parental responsibility for the child. Other respondents, the children's guardian. The child, if a party to the proceeding and there is no guardian. As far as it concerns proceedings for the protection of children and social work, the local authority will often be the applicant represented by a lawyer, and the other parties are usually parents and the children through their guardian. The other parties will come to court with their respective lawyers, but sometimes a parent or carer has no legal representative. What is the evidence in chief? The way to give evidence in court is to give an oral testimony of what you have already provided to the court in the form of a statement, care plan, or other reports. In the case of F versus R, Child Contact Order, reported in 1994, The Times, December 6th, the court stated that when written statements revealed that parties to the proceedings hold contentious and opposing views, it is inappropriate for the court to decide the matter without giving the parties an opportunity to deal by way or oral evidence given in the witness box with any contentions made against them. The evidence itself and how the evidence is presented will often be the difference between a strong case and a hopeless case. When the court hears your testimony or oral evidence and concludes that the case is hopeless, the court will either dismiss the application or decide not to make any order. In the case of S&P, Discharge of Care Order, reported in 1995, 2 FLR 782, the court dismissed the mother's application when the evidence revealed that her case was hopeless. Generally speaking, in care order proceedings, evidence in chief will be limited to your lawyer introducing you as a witness, asking your name and your designation, confirming the content of your written statement is your evidence, and then turning you over to the opponent lawyer who will ask you questions about your evidence. The opponent lawyer's questioning is known as cross-examination. What is cross-examination? The less the witness says and the slower the witness speaks, the more control they can maintain under the pressure of a lawyer cross-examining you. The key for a witness is to understand the facts that they believe to be the case and not add additional thoughts to those facts, lest they are used to undermine the testimony. Sticking to the brief known facts is key to the witness, making it difficult for the cross-examiner to make the witness appear confused, biased, or inconsistent. What is re-examination? Re-examination takes place after cross-examination. Your lawyer can try and remedy any damages you may have done in your case. It is a limited chance for you as the professional witness to explain or otherwise qualify any damaging or inconsistent testimony brought out by the opponent during cross-examination. Sometimes, if the damage has been done in cross-examination, a re-examination may not correct the damage. Finally, before we wrap up this video, let us now discuss the practical steps you can take to gain confidence as a professional witness, and let's answer the question, how do I maintain my confidence under fire? I mean, under cross-examination. Number 1. Practice, practice, practice. This is done by regular court attendances and giving oral evidence as often as possible. Number 2. Observe others. Attend court hearings to observe others give oral testimony as often as possible. Number 3. Mentoring. Ask an experienced professional witness in your department, team or organisation to mentor you in becoming familiar with court work. Number 4. Practice pacing your speech by talking aloud in private and looking straight. You can do this in front of a mirror. Hearing yourself speak on the subject generates confidence in expressing your thought in a structured way and avoids stuttering. Number 5. Watch this video over and over again. Number 6. Before any trial in which you are going to give oral evidence, ideally you should meet with your advocate a day or two before the hearing to go over the evidence. Ask your advocate for the weakness of the case and how to overcome the weaknesses. Number 7. Controlling the cross-examination. The professional witness has an array of tools to manage the pressure during the period when he or she is being cross-examined, and they include repeating the question you have been asked before answering it. Asking the cross-examiner questions such as, "I don't understand the question. Can you please rephrase the question? Come again?" When you need to pause or you need to gather your thoughts, hold the glass of water to your lips and take a sip of water. If there is no water before you, ask for a glass of water. Ask the cross-examiner to take you to the part of your report he or she is referring to and refer to your statement or report when answering the question. We hope you have enjoyed this video. Please send your feedback to admin@tinado.co.uk. Please subscribe to Tina Do on YouTube, like us on Facebook, follow us on Twitter and LinkedIn. This video is copyright to Tina Do Limited, August 2015.